Thank you, Alicia. This is Nancy Hart. I'm a senior program attorney at the National Council, and I am co-presenting this morning or today with my colleague Darren Mitchell, who is a consultant for the National Council. We are glad to have you here, and we have a couple of learning objectives we would like to go through before we proceed. During this webinar, you're going to learn about the Firearms Pilot Site Initiative, which we will maybe refer to today as the FPSI, including our project goals, the timeline and structure for the project, anticipated activities of the project, benefits for participating communities, and a little bit about the application process. We'll also talk about opportunities for communities to use existing laws to prevent abusers' access to firearms in both civil cases involving domestic violence, especially civil protection order proceedings, and also opportunities to do the same in criminal domestic violence cases. During this webinar, you will also learn about specific ways in which national and local experts will assist FPSI sites in planning and implementing project activities to take advantage of the opportunities described and to pursue other strategies to protect victims and others from firearms violence. And finally, you will learn more about the issue of firearms and domestic violence and about how to receive further assistance. I'm going to turn it over to Darren at this point to give a little bit of background on the scope of the problem.
Hi, everyone, and thank you so much for joining us to discuss this topic. We're thrilled that you're joining us. We're thrilled to be starting on this national demonstration initiative, which you'll learn more about in just a minute. But we wanted to sort of set the stage for the work. And to do so, we wanted to talk about some of the empirical research and public health research that's been done on firearms and domestic violence, and specifically on abusers' access to guns. Because the way we approach this project overall is that we're working on a public health issue, one of about the safety of not only domestic violence victims and their children, but of course those who have to intervene in cases, bystanders, and the broader public. And so we, in all of our discussions around this issue, we really do frame it around the public health implications of the work and preventing needless homicides and, of course, injuries from firearms and abusers' access to them. So some of the research has demonstrated that of all the risk factors in domestic violence cases for, in this instance, Dr. Campbell was looking at femicide across several studies and several communities, the greatest risk factor was the abuser's access to firearms above anything else. And some older research has shown that simply having a gun in a home increases the homicide risk if there's an intimate partner relationship and a gun is used by 8 times. And if there's a prior history of violence between that couple, it's a 20-fold increase of risk of homicide if there's a gun present in the home. In addition to that, the evidence of what's been happening over several years in this country in domestic violence homicides has shown that in more than 2/3 of the cases, male spouse or ex-spouse was killed by her partner. More than 2/3 of those cases involved a gun as the weapon of choice. And in fact, the gun was very much the weapon of choice. Guns were used more than all the other weapons combined during that period of time. There is some evidence, some recent evidence, that the proportion of cases in which guns are used to commit homicide in domestic violence cases has been going down somewhat. I think there's some newer research coming out. We'll learn more, which I think is we'd like to look at as a hopeful sign, and maybe some of the interventions we're going to talk about have been working. In addition to this information around homicide, Susan Sorensen of the University of Pennsylvania and others have looked at what a gun means in the context of domestic violence relationship, and the fact that guns are used not only to commit horrible violence, but they're actually used as tools to further power and control over an intimate partner, and they're used in situations of coercive control as well. So threats with guns, cleaning guns in front of the victim, and other things like that can help abusers to continue to exercise control, power and control over folks with traumatic impact on victims. If you haven't seen this research, there's a recent article that Dr. Sorensen published, and there's a couple of other pieces she's put out on this issue. It's very interesting and just really frames it in a different way from just thinking about homicides and injuries into how guns can be a tool in domestic violence. In addition to that, there's peer-reviewed research, published research to show that a couple of interventions have been effective over the years. One is that when guns are ordered to be surrendered by judges, that has a real effect on the guns actually getting turned into law enforcement and people not having access to guns. So having a court take a positive action has a real impact. Even in cases where the law would apply on its own, having the gun order the surrender does seem to have an effect on access to the firearm. The second, which I'll talk about in a little bit more detail, is that prohibitions based on the existence of domestic violence protection orders or restraining orders have a positive overall impact on intimate partner homicide in the jurisdiction in which those laws apply. So an initial study looked at state-level reductions in homicide and found there was a 6 to 7% reduction in states in which protection order codes ordered folks who were subject to those protection orders not to possess weapons. A more detailed and more focused study of some large cities more recently has shown a 19% reduction in those cities if there is a protection order law that says you can't possess guns. So there's some efficacy there in terms of laws that prohibit possession. There's still lots of issues around about the actual implementation of those laws, and that's really what our project is all about, as you'll see in a few minutes. The other interesting and important point about this is that if people are prohibited from having guns and don't get them and are denied guns, they don't appear to substitute other weapons for their firearms to commit homicides and kill their intimate partners. And so there doesn't seem to be a substitution effect, which is a very, I think, hopeful finding here, that if you can keep people from having access to guns, you may be able to prevent homicides in these types of situations. I'm going to turn it back over to Nancy now, who's going to walk us through a little bit about the FPSI project itself.
Thanks, Darren. And just apart from the research that Darren has just been summarizing briefly, the National Council has been involved in the intersection of domestic violence and firearms for 2 decades, and through a series of meetings and roundtables and many other discussions about this. So as Darren said, this is one of the reasons we're so excited about this project, because we are at the beginnings of being able to work with communities on some strategies that we have heard about that we are excited to be able to implement or help communities implement. And that's really the meat of what the Firearms Pilot Site project is going to be about. Some of the main objectives of the Firearms Pilot Site Initiative are to provide intensive technical assistance to 7 diverse pilot project sites working to improve their response to firearms in criminal and civil domestic violence cases. We plan to obtain and disseminate information about effective strategies and lessons learned. We'll be identifying approaches that protect victims and children and others, while also promoting victim autonomy and safeguarding offenders' due process rights. In fact, the next part of the webinar is actually going to go into some detail or a little bit of an overview of some of these approaches. Another objective of the initiative is to facilitate peer-to-peer mentoring and other vehicles to promote idea sharing and problem solving among communities. As I mentioned, we are going to be selecting 7 project sites. At least 2 of these will be tribal communities. We are going to be looking for broad diversity in these pilot sites. That would be diversity in terms of geography within the United States and territories, demographic diversity, diversity as far as legal framework. Some states have strong laws that of their own. Other states may have less legal authority, but there are strategies that work in all of these different environments, and we want to make sure that the sites reflect those diverse legal frameworks. Diversity in terms of leadership and diversity in terms of the challenges that are to be addressed. We know that many communities face similar challenges, but we want to be sure that we cover a range of them. We also plan to focus on both civil and criminal domestic violence cases. And the initiative includes an evaluation component that will be both quantitative and qualitative at the individual sites. And it'll depend on, what the sites have the capacity to do, but we will be, part of the project will be working with the sites to determine what those performance measures would be, so that we can include that in the overall project. It'll also involve intensive TA and training, peer-to-peer mentoring, as I mentioned, and some idea sharing. And perhaps most happily, it will involve some funding that we anticipate for a project coordinator at each site, as well as some funding for travel. The timeline that we're operating with is we plan to release a request for proposals to communities by early summer, sometime early June-ish. The applications will be due in late summer. We're anticipating, approximately a 90-day period during which the RFP would be out there. We will be then reviewing the applications and selecting sites by the middle of the fall, and then during the fall and winter of this year into next year, we'll be working with those selected sites to develop collaborative teams that will be on the ground in those communities. Following that, early next year, the sites will conduct a self-assessment and do some other planning activities in conjunction with that collaborative team, but also in partnership with the TA teams that we'll be working with. And then finally, next summer, those sites will participate in an all-sites meeting where they will all come together along with TA providers, and that will culminate with the beginning of the actual 3-year planning and implementation phase for each of the sites. So it's anticipated that this would then go on 3 years from the end of next summer. And we have another webinar already scheduled on June 5th. That one will be more focused on the application. The RFP will have come out by then, and we will be reviewing the RFP and talking a bit more about the application process. So today we're more talking about some of the strategies and an overview of the project, but that webinar will be more focused on the application process, and it will be recorded as this one is, so that if you for some reason can't participate, it will be available. I am going to turn it back to Darren, so he can talk about.
Thank you, Nancy. And yes, for the remaining, most of the remaining time that we have today, we wanted to give you a sense of our approach and the approach we're going to take in this project to technical assistance, to training, and to mentoring sites that we've found to be effective over the years in tackling these issues, and give you a sense of how we analyze and address the challenges presented in trying to disarm abusers and prevent domestic violence related firearms violence. So we're going to specifically look at what we see as opportunities within both the civil and criminal domestic violence systems to effectively intervene and remove guns and prevent further access to guns. Because we wanted to keep this webinar to an hour, we're under time constraints, we'll only really be able to sort of touch upon these and give you some overview information to give you a sense of what these opportunities look like, and a couple of examples of how communities already have taken advantage of them to try to provide some safety for victims and others. And of course, during the FPSI project itself, the sites will engage in very intensive efforts with our assistance and assistance of mentor communities and others to identify which of these opportunities they want to take advantage of and which approaches they would want to take that would work in their particular communities. But before we dive into those specifics, I wanted to say a couple of words about our sort of philosophy and approach to these issues. As Nancy mentioned, we've held several roundtables and convenings on firearms and domestic violence, and we've also surveyed the field a few times, including all of you who are participating today had an opportunity to answer a couple of questions on the registration form, and those who did, most of you did. Thank you so much for doing so. It's a very helpful information, and I'll refer to that again a little bit later on. But as a result of all this information gathering and the technical assistance that we've provided folks over the last couple of decades, we've learned that even though there are a lot of these sort of specific resource and legal and procedural, technological challenges out there to preventing firearms related violence and DV cases, we know that any effective approach really must include strong leadership, which of course can come from various stakeholders. It doesn't have to be a judicial officer or a law enforcement agency. It really can be, leadership can come from lots of different places. That there needs to be real buy-in and meaningful collaboration of all the key stakeholders within a community, all the agencies and professionals who are involved in the process. And finally, that any approach really needs to take into account and address the culture of the community, including what many people talk about as gun cultures, as a gun culture in their community. So we are very cognizant of all of these different critical components, and they're built into everything that we do and will be part of our work with the pilot sites under the FPSI. We're not going to address those aspects specifically today. We're really doing a sort of the CPO process and the criminal process to give you some ideas of how we can do better in those areas. But just keep in mind that this project, if you're struggling with any of these kinds of challenges, and I know many of you are based on your responses to on the registration form, this project will certainly generate strategies and approaches that can help you in your work. So now having said that, let's turn to the civil protection order process and take a look at what we have identified as elements of an effective system or opportunities to intervene. And you can see our layout here. It's all about getting information and issuing orders and making sure people understand the orders, using service, which not enough communities do, as an opportunity to learn about and maybe obtain firearms and prevent further access. How to, once orders are issued, monitor compliance with those orders and respond appropriately. And finally, there's the issue of if folks are no longer prevented from having their guns as part of the process, how can we make sure that the return process is a safe one? And underlying all of this is, as Nancy mentioned, what we consider to be critical components of victim autonomy, which is really about maximizing victims' voice in the process and choice over what happens. Not saying that it dictates the process, but that we take every opportunity to maximize victim input in what happens. And also, of course, we always have to be protective of respondents' rights, their due process rights, their right not to injure themselves, and the right to full and fair hearings on these issues. So everything we do, again, is going to incorporate ways to maximize victim autonomy and way to appropriately protect respondent rights. So let's start off with the getting the information piece, which of course is critical. And in fact, there's research showing that having multiple opportunities to get information about respondents' access to firearms can be critical to learning about them and getting them. So obviously, there are lots of different ways to get the information about access to guns. We list some of them here. Some of the critical ones are using advocacy services. Advocates can have, as you know, confidential conversations with victims about whether guns are an issue for them, whether they feel threatened by guns, whether they think that they should use a CPO process to go after the respondent's guns. They may or may not want to do that, and various other aspects of this issue. And so using questionnaires and interview guides, and I'll give you an example of one in just a couple of minutes, can be a very effective tool in that process to learn about respondents' access to possession of ownership of weapons. Petitions themselves, along with supplemental forms, can be a good place to have petitioners list what they know about gun access if they're scared of the respondent's access to guns, where the guns are, and what the guns are. Law enforcement, of course, can fill out domestic violence incidents reports when they're called to a scene, talking about whether any threats were made or guns were used in the incident, and what they've learned about respondents, defendants' access to guns as part of that process, which could be fed into future steps in the CPO system. Training everyone and anyone who comes into contact with victims and offenders about guns, this issue, and about how to obtain information about guns can be a critical aspect of all of this. Providing petitioners with informational brochures about guns, what to do if you're afraid of, if your abuser has guns, what can be done about that through the legal system in multiple languages, and that are going to be received and understood by victims, potential petitioners in the CPO process, are all really great tools to use. Finally, civil and criminal court records being made available to CPO judges can give a sense of whether guns have been used in the past in previous instances and whether there's any access to guns by the respondent. So those are all some of the ways that we look with communities to figure out whether they're getting all the information they can. There are other ways as well, but those are the prime ones. And we wanted to give you a couple of examples. So Wisconsin uses this petitioner statement, which is a voluntary optional form that a petitioner can fill out if she or he chooses to alert the court to the issue of guns. And as you can see, it provides ample space to give very specific information about firearms so the court can do something about them. And Wisconsin, if you don't already know, has a very robust system for learning about and responding to firearms as part of the protection order system. In addition, some locations, and the first to do it that we know of was Miami-Dade County, asked respondents upon service of a temporary ex parte order to fill out a sworn statement or declaration indicating whether they possess guns, and if they do, what the guns are, as a way to get that information. Finally, I'll show you a tool that has been developed by one of our sister organizations that's a partner on this project. The National Center on Protection Orders and Full Faith and Credit have developed a SAFE tool, which is an advocate's guide to interviewing their clients about guns. And it includes things like pictures of guns. So if there's a description that's needed on a petition, the advocate can work with the survivor to figure out what the gun is and describe it appropriately on any petition. So that's the information stage in a nutshell. A second important part of this process is to ensure that orders are issued that are clear and fully enforceable. And actually a big component of that is to ensure that courts exercise the authority they have, whether it's mandatory authority or discretionary authority, to order folks not to possess or purchase guns and potentially, if it's available, to surrender any weapons that they already own or possess. And so this gives you a sense of, around the country, the states in which there is explicit in the law authority for courts to prohibit possession or purchase of firearms, much of the country. Less of the country has specific authority to order surrender of existing weapons. You'll see that this map shows you some states where it's mandatory, the court must order surrender when they issue a protection order in certain circumstances, and in other places there's discretionary authority to do so. There's also, this is explicit authority, so it's written directly into the statute. As many of you, I'm sure, know, there are catch-all provisions or any other relief aimed at protecting the victim and children may be available in the statute. So-called implicit authority can be used in other places in the country. And in fact, there's some very robust firearms surrender systems that have been developed around that kind of discretionary implicit authority as well. Of course, no matter where you are, we would work with you to find what your authority is and how to best take advantage of it in these cases. So in terms of issuing effective orders, things to think about include what courts should do, which, as I said, exercise all available authority in particular case to ask to either order that guns be surrendered or that there's no possession of firearms. If the court does enter an order around surrender or in some cases seizure, specificity is the key. Which firearms, where are they, and what are the instructions, especially for surrender? How do you surrender them? When, where, how? And this is key to compliance and to monitoring compliance. And we have lots of examples of orders that are for that kind of specificity and appear to be effective in getting respondents to turn in their guns. In addition to that, we want to always be thinking about the federal firearm prohibitions. We didn't spend a lot of time talking about the federal and the state and the tribal laws in this area just for time purposes, but I'm sure most, if not all of you know that there are federal prohibitions, both in terms of misdemeanor crimes of domestic violence, people who've been convicted of those, and certain protection orders issued by state tribal courts that meet particular requirements. And to ensure that your orders meet those requirements and can effectively serve to prohibit possession under the federal law, there are some steps that can be taken in terms of getting orders entered into state and federal databases that are searchable when someone goes to purchase a gun or by law enforcement on the scene, developing protocols and ensuring that personnel indicate orders that accurately that trigger this federal prohibition. And there are other things as well that we talk about here in terms of interaction with FBI and the folks who would do the background checks on the federal level to ensure that those are effective processes. So whenever you're thinking about the effectiveness of orders, you should be thinking about your state tribal laws, but also the federal law. And of course, this is something that we can provide lots of assistance with, and we have federal partners on the FPSI project to help with just this. So a couple of examples, again in Wisconsin. They have developed a specific order to surrender firearms, and notice that there's going to be a hearing coming up, which has very specific information about what the respondent needs to do, including on the second page of the form is a listing of exactly which guns need to be turned in and room for additional instructions as to where and when they should be turned in. So there are other examples we have that we're happy to share with you, and we've done a lot of work around trying to adapt systems like this to what you need in your both in terms of your legal authority, in terms of how your law enforcement agency is set up, and what your community is able to sustain. Next, a very important and sometimes not a lot of time is devoted to making sure that folks understand what their obligations are and how to get orders enforced around firearms. And so there are lots of different strategies for this. We just wanted to briefly point out what Multnomah County, which is Portland, Oregon, has developed. They developed several forms that are aimed at helping respondents understand what their obligations are around guns when a Family Abuse Prevention Act order, or their version of a civil protection order, has been issued. And you can see here's an example of a frequently asked questions document that they put together that it puts in very simple terms what is expected of a respondent who has a FAPA order issued against them. We have other examples of these, and of course would be happy to work with you on developing some that work for you. I'm going to turn it over now to Nancy, who's going to take on the last three aspects of the CPO process.
Yeah, thank you, Darren. And I just want to acknowledge that this is a lot of information that we're covering fairly rapidly and fairly, not superficially, but certainly not in depth. And so just to realize that we want to give you a taste of what's available, but it is a lot. So as Darren has mentioned, one of the elements of an effective system is to utilize the service of process as an opportunity to obtain firearms, and this is something that is a great opportunity that is underutilized. This primarily is directed at law enforcement, but one of the key things that can be done is to have court and advocacy organizations collaborate with law enforcement on developing a protocol that delineates roles for law enforcement and advocates in conducting safety planning prior to service. A protocol can provide for obtaining information to facilitate safe service and recovery of firearms pursuant to the court order. And a protocol can provide for how the victim is going to be notified and what kind of follow-up safety planning is going to be conducted and by whom if firearms are not surrendered. And again, I apologize for how brief this is, but a protocol is obviously a big undertaking, but something that's very helpful. Law enforcement can also inquire about firearms and seek voluntary surrender upon service by the respondent, or to seek voluntary surrender by the victim at the time of service, or other household members. And there are other creative options for storing firearms. For example, storage by a federally licensed firearms dealer. And in most cases, there are some states that have actual laws, if not practices around this, and then the firearms dealer can charge the respondent for that storage. So there are a number of different creative ways to think about how to approach the storage problem, which we know many jurisdictions face. Another really key element of an effective system is monitoring compliance. And, you know, some of the elements of an effective compliance review system are, of course, as Darren has been talking about, issuing clear orders that include specific deadlines for the surrender or return of firearms and specific descriptions of those firearms. The more clear the orders are, the easier it is to determine whether the firearms have been surrendered, and the right ones, or all of them. Another important element is that there be clear instructions on where the guns need to be turned into. What's the process? What type of proof is required? Do you get a receipt, or do you have to fill out an affidavit? Or we'll touch on this briefly, if you are permitted to give it to a third party, what kind of affidavit or receipt does the third party need to fill out? All of those things need to be clearly identified in written instructions that are available to, of course, the respondent and the petitioner as well. It's helpful to have designated personnel, both in court and law enforcement, for helping to monitor compliance. A critical element of a monitoring system is to have a review mechanism, and you know, ideally there's direct communication between the court and law enforcement agency on whether or not surrender has been accomplished and when. Again, using receipts and affidavits as evidence. Good practice is to set a hearing to review whether it has been complied with, and it can always be canceled if the necessary affidavit or paperwork comes in and validates that it's been returned or surrendered, or the respondent can provide proof of compliance himself. Another element of an effective monitoring compliance is a mechanism for addressing non-compliance, and we have a few examples that will follow this. You can issue a search or arrest warrant. Certainly can conduct an order to show cause hearing or a contempt hearing, and a prosecutor could charge violation of the order. I'm going to very quickly show you a couple of examples. This is from Oregon, and this is something that the respondent would sign, and there you can see there's 3 boxes to check. Either you've surrendered, or you have identified a third party that you were planning to surrender to, or you are saying that you do not have firearms or ammunition. This is a sample from the state of Washington, and you can tell that this is an affidavit of proof of surrender. The court, again, signed by the respondent, identifies the date and place and specifics of the surrender, and is filed in court. And this similarly is a declaration of non-surrender, which is to say that either there are no weapons and that you therefore have not surrendered them. These are signed under penalty of perjury and filed in court. Another example is this receipt from Wisconsin, a county in Wisconsin, which is signed by, well, has the respondent's name, is actually signed by the receiver at the law enforcement office, the sheriff's office in this case, again with the detail on the make and model of the firearms that have been received. And this is a form from Oregon, I believe, just showing an order to show cause.
It's actually Florida.
Oh, sorry, Florida.
Miami.
Sorry. That is what you would do if you were going to pursue an order to show cause as a mechanism for ensuring compliance. I think that is the end.
I wanted to just add one quick thing, Nancy, to this
Sure.
monitoring compliance piece, if that's okay. And of course, this is really, a lot of our effort is focused on this follow-up portion. And some folks in the registrations pointed to as a real challenge is so much of this seems to be built on trust, what the defendant says or respondent says about the firearms they own, and whether they've all been turned in, and how do you know they've all been turned in, and what's going to stop him from getting another one, even if you go through a process like this. And those are all valid concerns that, of course, we're aware of, and that folks that we've worked with in the past have been trying to address. And we certainly have some ideas about how to get more additional information about weapons that can sort of corroborate what the respondent tells the court about them. And this certainly, I think, going to be a focus for communities as part of the FPSI, is to figure out how we can get at some of those gaps. So if those are challenges that you all are facing, this is certainly a project where we think we can help you.
Yeah. So the last element of an effective system is the safe and effective returns process. And, you know, as with all of these, collaboration is definitely required to develop and implement an effective return process. You can require respondents to petition for returns. That's done in a number of states that are identified here, as well as others. In California, they use a law enforcement petition to prevent return, which is another way of approaching it. You want to make sure that the victim is notified, but also that the victim's appearance is not required at a hearing, so that they know that the weapon has been, or weapons have been sought to be returned, but so they know about it, but they don't have to be there to prevent it or to allow it. And then, of course, that a criminal background check should be part of the process. And many states have forms that are the equivalent of a Brady affidavit, which, you know, specifies that the person has not subject to any of the prohibitors, not convicted of a domestic violence misdemeanor, not subject to a protection order. That kind of thing should certainly be used before a weapon is returned. This is a sample of a motion for return from North Carolina, and again, you can see from the questions that it asks the respondent, do you have any criminal charges in state or federal court? Have you ever been convicted of a misdemeanor crime of domestic violence or crime of violence, including domestic violence, ever convicted of a felony? So it's extensive and allows the court to know what the history is. This is a very brief talk about the third-party transfer, which is not just relevant at the returns level. Obviously, third-party transfers happen at an earlier stage when someone is trying to surrender, but it also can be implicated when you're talking about a return. And it's important to develop protocols and forms to prevent sham third-party transfers. There are a number of steps that can be used. You can use an acknowledgement form, like the ATF acknowledgement form, or other examples that are signed by the respondent and a third party, and the third party, sorry. Requiring the third party to appear in court is something that a number of jurisdictions have done, and that provide warning to the third party directly in court, to both the third party and the respondent, about the consequences of the third party delivering the firearm back to the respondent, including a directive in any order to not permit possession of firearms by the prohibited person, so that the third party is well aware of the consequences of their willingness to receive the firearm. If possible, it's good to require the transfer through law enforcement or a federally licensed firearms dealer, which would also include a background check prior to transfer to the third party. I don't know how often that's done, but it is ideal. Darren, do you know how often that's done?
Yeah, I'm not full of examples of places where it's done, but I haven't really surveyed the field to see
Right.
how frequently it's used.
So we do have an example of a third-party affidavit from Oregon, and again, it's something that the third party is identifying who they are and being sworn, and then attesting to the fact that they're aware that they're prohibited from, that the respondent is prohibited from possessing the firearm, but they also understand the consequences to them personally if they are to make that firearm available to the respondent. And they subsequently lower down, agree to not return or loan the firearm, and then it's signed and submitted. I think that is the end of the civil section. And again, just want to acknowledge that it's a lot of information and we kind of skimmed over a lot of different things. But so I'm going to hand it back to Darren to talk about some of the criminal DV cases.
Yeah, we'll continue our whirlwind tour through the legal system and the opportunities to intervene in these cases. And we want to make sure to cover criminal domestic violence cases as well. I know a lot of the focus around firearms and domestic violence historically has been in the civil protection order system, but there's lots that can be done in criminal domestic violence cases as well. Some of what we've already talked about in the CPO context is applicable to criminal domestic violence prosecutions and cases where there's a conviction. But we wanted to focus in a little bit more on some of the unique opportunities that those kinds of cases present. So again, we have a little roadmap for you all, and we try to do this sort of soup to nuts. So we start with the first intervention through a 911 call, an initial law enforcement response to the scene. What happens in terms of pretrial hearings and orders that can be issued in that context before there's a trial. And then the impact of pretrial negotiations and ultimately a plea agreement, what that means for firearms access for the defendant at this point. Then through trial and a conviction and sentencing, there are additional things that can be done to try to either get guns taken away or prevent future access to the guns. After conviction, when there's still some supervision by probation and parole officers, there's some opportunities. And finally, if there are orders anywhere along that path to turn in guns or not possess them, questions of how you can effectively monitor compliance with those orders arise in the criminal context just as they do in the civil context. So I'll dive right in and start talking about the 911 call and the initial response. And generally speaking, these are real opportunities, again, to learn about, of course, access to guns, even if the gun has not been used in the specific incident that resulted in the 911 call and the response. But the 911 officers handling 911 calls, the folks who are responsible for that, should have a protocol in place that talks about, most of them do have a 911 call protocol for, I should say, many have a 911 protocol for domestic violence calls, but part of that should be how firearms, whether they're being used in the incident or you want more information about guns, can be addressed as part of that 911 call. And certainly questions about whether the abuser has a gun at the time or whether has access to guns would be, you think, for officer safety and as well as for victim and community safety, one of the questions that needs to be asked. In addition, the 911 operator can, in many places, do a search, a quick criminal background history search to find out what's going on in terms of any orders issued that may be violated, including gun aspects of those issues and convictions and things like that. So 911 operators certainly have a role to play in all of this. As well, a domestic violence protocol for law enforcement officers should have specific instructions for how to address firearms in cases for line officers who are responding, including what their authority is to obtain weapons, either through seizure of the weapons or requesting voluntary surrender of the weapons, and the legal authority upon which they can take guns at the scene. That authority, I can tell you from working on this issue for quite some time, can be kind of murky in many places. And we found ourselves trying to work with folks. Often we'll work with lawyers from law enforcement agencies or from government entities that advise law enforcement agencies to help them figure out exactly what their legal authority is under those circumstances, including what they can do if they know that there's a federal law violation as state officers. So this is something that we help people with on a pretty regular basis. Finally, mandatory domestic violence incident reports don't do a good enough job, in my experience, of including information around firearms, access to firearms, possession and use of firearms, and also getting the information that you would need in terms of numerical identifiers, date of birth, social security number, driver's license, and state, and all that kind of stuff, so that you can get information entered ultimately into the federal databases so they can stop purchases and be the basis for a federal prosecution. So that's one of the things that I'm sure, going to be working with sites on, is figuring out whether their incident reports do an adequate job in capturing this kind of information. I just throw this up here as an example of a law enforcement protocol specifically around firearms that was developed by the San Mateo County, California Sheriff's Department, that has lots of good direction for line officers and for supervisory officers around what can be done for domestic violence cases around obtaining firearms from offenders. The next stage we move into is the pretrial stage, where there may be an initial hearing. They're called lots of different things. It may be a pretrial hearing where the court is considering bail or bond, conditions of release, things like that. So for those pretrial hearings, there's several things to think about. One is, whatever court services agency, and hopefully you have one, whether it's probation or some other community supervision or other court service, can ask questions about firearms ownership and access, obtain information from databases and elsewhere, and incorporate that information into any bail recommendations or bond recommendations or condition of release recommendations that those services provide to the hearing officer on that pretrial hearing. In addition, prosecutors who will be appearing in the cases their offices can themselves investigate firearms issues and request appropriate relief, including, in many places, an order to surrender firearms as part of the prosecution of the case at this pretrial stage. In addition, we talk to judges about ensuring that they understand the scope of authority that they have to prohibit possession of firearms or order surrender as part of this order that they're going to issue pretrial, and to include it in those orders. And there are examples, that we have several examples of form orders that have been standard orders that have been developed by states around the country that include information around guns. And in fact, Illinois has a supplemental order that goes along with the condition of bond order that specifically addresses firearms. And you see part of it in this example here. There are other examples of this as well, and having a separate, specific order around guns, again, as in the CPO context, makes a real big difference in terms of clarifying to respondents and to victims about what needs to happen next, and to ensure appropriate monitoring of compliance with such orders. Of course, a fact of life in all criminal court contexts, but also in domestic violence contexts, are pretrial negotiations and ultimately plea agreements, and sometimes things like deferred prosecution, where the prosecutor's office decides to hold off on the prosecution and gives an opportunity for the offender not to reoffend for a period of time, and ultimately the case will be dropped, and there are diversion programs as well. Of course, there's a myriad of different approaches that communities around the country use, but all of those offer opportunities they offer challenges in terms of offenders falling through the cracks. So if cases are pled down from assault, for instance, to disorderly conduct convictions, you may lose the ability to have someone subject to state and especially federal firearm prohibitions. And so prosecutors really need to be aware of the impact that a plea like that is going to have on potential firearms prohibitions and the ability to order surrender firearms in such cases. And prosecutors can include safeguards around guns in the negotiated plea agreement, and include terms in the ultimate order, or urge the court to include terms in the ultimate order around no possession and potentially surrender of firearms. In addition, deferred prosecution, as I mentioned, and diversion programs, where there's not a full prosecution, offer an opportunity for prosecutors to ensure that any court order around a deferred prosecution or a diversion includes firearms prohibitions. And I'm going to give you an example of that in just a minute. And then finally, the plea issue that I mentioned, judicial officers in accepting a plea, especially to a lesser offense that may not trigger particular federal firearm prohibitions, may have the authority to include surrender or no possession prohibitions in the ultimate conviction, order of conviction, based upon the plea. All things that we work with prosecutors and law enforcement and judges around the country on trying to include in their systems. Here's an example from Indiana, and Indiana has a fairly robust set of forms in the criminal context around diversion, their diversion program, around pleas, and around probation and parole that include firearm prohibitions. I would prefer to see something a little more specific, and potentially also include a surrender provision, which I think is appropriate under the circumstances and authorized, but they have at least, as part of this, a prohibition on possession of firearms as part of this diversion program written into their form order. I'm going to turn it over now to Nancy, who's going to talk about the remaining opportunities in the criminal system.
So I am going to try not to cover too quickly, but jumping right in, we're going to talk a little bit about the trial, conviction, and sentencing stage of the process. To facilitate implementation of federal prohibitions, the official court records need to show the actual elements of the applicable criminal statute of conviction, not just a citation to the general statute. And many of you know that a lot of state statutes have many subsections involved, and it's important to be very clear in the record of conviction which elements the person has been convicted of. And I'll show you an example in just a minute. The official court records should also indicate the qualifying intimate partner relationship. They should indicate whether legal representation was present, or if there was knowing and intelligent waiver of that right, and then whether there was a trial by jury or a knowing and intelligent waiver of that right. The records of conviction should also be transmitted to the FBI's III in a timely fashion, and even though there's not a definite rule on what that is, it should be as quickly as possible. There should be no delay involved in waiting on that, because the sooner it gets into III, the sooner it's out there for enforcement. I'm going to show you a sample form. This is from state of Oregon, which is a sample conviction record that has findings for federal firearms prohibition, and you can see that it concerns a misdemeanor conviction that may subject the defendant to federal prosecution for possession of firearms, and there's a number of things to check under the relationship box. And then down below you can see that there are the specific elements of force that were involved in this conviction, so that you can be clear in your order what the elements of the crime were for purposes of federal firearms prohibitions. Going to move quickly to the post-conviction and probation parole stage of the criminal process. Here, probation and other post-conviction orders have a real role in helping with this. They should include clear and enforceable provisions regarding firearms, including, where it's authorized by law, any surrender provisions that might be helpful. Probation protocols and processes for offender supervision should include monitoring compliance with orders, to not possess firearms, and other firearms-related issues more generally. This allows probation personnel to assist in the process of receiving surrender and reporting surrender to the court. And if there's a process in place to address firearms violations and offenses as well. This is a sample from the New York Model Policy on Domestic Violence for probation response to domestic violence, and it delineates a number of things about notifying the offender about firearms prohibitions. That's a role that is that probation can play that's very helpful in reminding the respondent that he is subject to these prohibitions, describing the consequences of failure to comply, and then having probation involved in verifying firearm surrender and even employing search orders or search conditions to facilitate the confiscation of those firearms. And finally, we come to compliance monitoring and safe and effective returns process, which we've talked about more extensively in the civil side, and just they pertain to the criminal side equally. Again, just to review quickly, under compliance monitoring and return, you want to make sure that orders are clear with clear descriptions of the firearms and clear deadlines for when they need to be surrendered. Clear instructions and complete instructions about the process for surrendering your firearms, designated court staff and designated staff at law enforcement, so that it, again, all for making sure that the process is as well described and clear as possible, with a review mechanism for whether it's paperwork being returned to court in the form of a receipt or in the form of an affidavit, or scheduling a hearing that can be canceled if the paperwork shows up, some kind of mechanism to ensure that there is compliance. And then finally, a response to noncompliance, which would be to either issue a search or seizure warrant, or to have some kind of a contempt hearing or prosecution for violation of the order. I do want to acknowledge again that this has been sort of a race through the strategies that we really dwell on in our work as TA providers, and this is all stuff that we provide TA on to and will be focusing on in the 7 communities that we'll be selecting in this project. We want to spend just a couple of minutes, and I'm going to hand it back to Darren for this part.
Thanks, Nancy. So as you know, we asked you all a couple of questions to help us understand what you're facing in terms of participating in a project like this for your community. And again, many of you responded. So I wanted to share a little bit of information about what we learned in the responses, and we've prepared a little chart to sort of lay things out. The responses that you all sent to your challenges to participation are consistent with lots of the things that we've learned over the years in working in this area, and highlighted a couple of points that we thought we'd spend the last couple of minutes talking about. Of course, funding, lack of resources, lack of staff time to devote to a project like this was something that was raised by very many of you. And by the way, these show the total number of responses. Many people responded with something that's not on this list because they were the only one, or they were one of just a couple of people who had that challenge. And of course, we can make those available to folks if they want to see the full scope of what people said. But we stuck to ones that had at least 4 people who thought that was an issue. Next is really, I think that you can look at the gun culture issue, hunting rights, and a strong gun lobby and gun rights advocates, and concerns about the Second Amendment sort of together in gun culture, although hunting rights, of course, can be challenging. I mean, hunting rights can be the sort of recreational hunting rights, but within tribal communities, it can be subsistence hunting and have a special aspect to it. But in any event, if you look at all those 3 together, sort of, that is actually the most, that was the greatest number of responses. I think it adds up to 23 or something like that. So lots of you are concerned about doing this work in the context of your community's culture around guns. And as I said earlier, that is certainly something that we're focused on and are planning to provide a lot of assistance in. Stakeholder buy-in, we were actually quite pleased to see that come up in the second highest up there, because that's a big focus, as I mentioned earlier as well, getting everyone to the table, meaningfully participating in collaborative efforts to address this problem is the only way we're going to make any progress. Folks acting on their own really can't do a whole lot. Even if you are the judicial officer in your community, without the other stakeholders involved, there's little you can do. So that's a big focus for us as well. Lack of knowledge and awareness, helping both stakeholders and the broader community understand the public health challenge that I very briefly discussed earlier, and the possible responses to it and why it's important to do this work is certainly going to be a focus for us. Laws and policies, well, to the extent that there are laws that make it difficult, we can help with workarounds. To the extent that it's policies or lack of policies, which a couple of people pointed out, again, that's what we're working on, is getting sustainable policies and protocols in place to help communities address these issues. You can see some of the other ones as well, including that it's sometimes a difficult topic to bring up in your community. And one of our focuses in this work is around communication and obtaining buy-in through how you approach the topic, how you communicate about the topic, and we actually have an expert working with us as a partner in the project to help us and help the communities we're working with address that particular challenge. So I think we're over time right now, and I really don't want to ramble on any longer, but we promised that we would tell you where you can get more assistance on these issues. Here's contact information for the National Council to reach Nancy and to reach me through this. The National Resource Center on Domestic Violence and Firearms, a new project which is really a continuation of something we've been working on for several years, run by the Battered Women's Justice Project, and their website has lots of great information to support this work. And in terms of research, the Johns Hopkins Center for Gun and Policy Research is really spearheading and collecting lots of important empirical support for the work we're doing as well. So we definitely commend their website to you in addition. And of course, we thank our funder, the Office on Violence Against Women, so much for the support of our work over the years, and especially for committing this level of resources and devoting this much, elevating this issue